There is more breaking legal news involving former President Donald Trump, this time in a different case, the classified documents case in Florida. A federal judge has rejected the request from special counsel Jack Smith. He requested a gag order against Donald Trump. Let's bring in CNN's Caitlin Polans. Caitlin, tell us more about this ruling, which came just moments ago.
Yeah, Jake, so prosecutors from the special counsel's office at the Justice Department are not going to be able to limit Donald Trump's speech about law enforcement who were part of that Mar-A-Lago search in August of 2022 at this time because they didn't follow the proper procedure. That's what Judge Aileen Cannon just said moments ago. The prosecutors had gone to her on Friday in the evening, right before the holiday week, asking her to put limitations on what Donald Trump could say because he was out there talking misleadingly about the FBI policies around the use of deadly force, a policy that was standard and in place for that search of the resort in Florida. But Trump was trying to say that he was in danger because of it. That was not true. So the prosecutors wanted to protect the proceedings, protect their own officers, and have a gag order. They felt that it was a very dangerous situation, so they went to the judge. Trump's team, though, took issue with this because they said they didn't have enough time to think about this and to respond and meaningfully work with the prosecutors to provide some sort of meet and confer. That's what they say in court. And so Judge Cannon today agreed with Trump's team. She said this was unprofessional and not courteous in the way that the Justice Department went about this, coming to her with the gag order request, that anything in the future, they need to have more time given to the defense team. And so she's denying they could always try again. But as of now, no gag order for Trump in the Florida case.
All right, Caitlin Polans, thank you so much. Let's discuss this for a sec. So I know that there is concern among people in the special counsel's office in the Justice Department that Donald Trump and his allies suggesting inaccurately that his life was at risk during this raid. I don't even think he was on the grounds of Mar-A-Lago, but there had been some sort of standard cut and paste procedure for what kind of deadly force the FBI is allowed to use. But because of that, they are turning this into, Trump and his allies, into, look, Joe Biden was trying to kill me, which is not true. Is that why he sought this special gag order?
Yes, that's exactly why. So this all springs from Donald Trump's preposterous, false, ridiculous BS claim that there was some effort to assassinate him. There's a document, a standard piece of a search warrant that says, hey, federal law enforcement agents, when you're executing this search warrant, there are very, very limited circumstances where you can use lethal force. It's the correct statement of the law. It's in every search warrant. And Donald Trump wasn't even there that day. So DOJ now.
Can I just to quickly interject? I thought I saw a Washington Post story that said it was the same exact rules and procedures when they searched President Biden's house.
It was. That's correct, because it's a standard.
Who also was not there at the time.
Exactly.
Okay.
Jack Smith now went to Judge Cannon in the classified documents case in Florida and said, we'd like a gag order to stop Donald Trump from saying these kind of crazy, incorrect, potentially inflammatory things. And what Judge Cannon has just said is, you haven't done this correctly, procedurally, Jack Smith, because there's a requirement known as meet and confer, meaning you just have to do the prosecutor, you have to call up the defense lawyer and try to work it out amongst yourselves, some meaningful exchange of ideas. And Judge Cannon said, well, you didn't do that, so go back and give them a call. It's quite clear where Donald Trump's team is at, right? They're not going to agree to anything. So technically, Jack Smith's team just needs to make a couple calls to Donald Trump's team, say, do you agree to any gag order? Trump's team will say no, and then Jack Smith can go back to Judge Cannon and say, now we need the gag order.
All right, let's go back to the case at hand, where Todd Blanche right now is summarizing the case. It's closing arguments today. First, the defense goes, then the prosecution will go. Todd Blanche is the chief attorney for Donald Trump in his defense, and he's suggesting because the story was already out there, this has to do with the Stormy Daniels story, how could the suppression of it have anything to do with election interference? Blanche turns to Stormy Daniels. He notes it's a story that took place allegedly in 2006, 18 years ago. Trump and Daniels have repeatedly denied that it happened. It was already published in 2011. How could it influence the election if it had already been out there? And then he talked about Cohen paying this without Trump knowing. And the narrative that Todd Blanche is trying to create is that Michael Cohen did a lot of things to try to get credit, to try to curry favor with Donald Trump. Blanche says Cohen paid this money to Stormy Daniels without Trump knowing, is another way to get credit from him. Quote, people were not happy with him on the campaign, so he made this decision. The only person who suggests otherwise and tells you President Trump knew everything about this is Michael Cohen himself. That's it. There's no other proof of that. There's no way that you can find President Trump knew about this payment at the time it was made without believing the words of Michael Cohen, period. And you cannot. You cannot believe his words, Todd Blanche says. The public was aware of them. This is because of the 2011 story that In Touch magazine did about Stormy Daniels. Blanche said because the story was already out there in 2011, it wasn't election interference and did not cause panic in the Trump campaign. The public was aware of them. So again, the idea that when Miss Daniels surfaced in 2016, it caused some sort of panic amongst everybody is not true. It's just not true. Blanche refreshes the jury on text messages they saw between Dylan Howard, that's the editor-in-chief of the National Enquirer, and then Stormy Daniels' manager, Gina Rodriguez, about selling the Trump story in April 2016. If there really was a catch-and-kill conspiratorial relationship, Blanche asks, then why did everybody ignore the story in April? Why did it not go anywhere for months and months and months? Blanche says you didn't hear from Dylan Howard, and you did not hear from Gina Rodriguez, so really it's speculation. Daniels and Rodriguez were more aggressively trying to sell her story, Blanche says. Mr. Howard is willing to help them. He wants to help Ms. Daniels and Ms. Rodriguez get money. That's not a conspiracy involving Mr. Pecker, President Trump, and Michael Cohen. And the jury is taking a brief morning break, as is Judge Merchan. Once again, Karen, an attempt to undermine Michael Cohen's entire testimony and also the prosecution's entire theory of the case.
The problem is Todd Blanche is literally throwing softballs to the prosecution. I mean, he's making arguments that easily, if I'm the prosecutor, I'm writing down saying, okay, you say, where is Alan Weisselberg? Why didn't he testify? Where is Mr. Schiller? Why didn't he testify? If I'm the prosecution, I'd say, these are people who are friendly to Donald Trump. If they had anything to say that was positive, then you would expect that Donald Trump would call them as a witness. And he did it again just now when he made this argument is why weren't they buying the story in April? What was happening? Why did it take so long? Well, that just buys into the whole prosecution theory because it wasn't until right before the election that they cared. That makes it criminal, right? Because it's about the election. And so I think they just are really kind of missing what their strong arguments are and making arguments that the prosecution, I think, has a much better explanation for. And it really just plays into the whole prosecution theory.
And don't forget, Access Hollywood is still this elephant in the room. I mean, the timing of all of this, what would have been the straw that broke the political camel's back? The defense wants the jury to look at all this in a vacuum. That's virtually impossible to do because there's evidence that's already come in, and these people were all living in the real world around probably the same time this is happening. So you have these issues about the softballs that Karen spoke about, but also they're trying to plant these seeds of doubt. It is very reasonable for the defense to say, here's who you did not hear from. You didn't hear from Alan Weisselberg. You didn't hear from Mr. Schiller. You didn't hear from Dylan Howard. Why not? They want that lingering question as to why not, to suggest that the prosecution could not have made their case without them and did not. But they went to such great lengths throughout the duration of this trial to pre-corroborate the testimony of Michael Cohen. The prosecution came up there and say, this was not coming down to just the testimony of Michael Cohen. It's coming down to all the documents that supported it in advance. Those who were friendly to Trump, those who were not friendly to Trump, they all had some bite at the apple to try to corroborate Michael Cohen's testimony. And so when you come back and the prosecution has time to actually do something about this, they can say it never came down to Michael Cohen. It came down to all of the different people who testified in advance of his testimony about why you should believe him. It can't just be the documents. It can't just be him. It's the documents.